My name is Nelson Mock, and I'm an attorney with Texas Rio Grande Legal Aid, and I'm in the housing law group.
There were 53,000 eviction cases that were filed in Harris County, and obviously, a lot of this is relative to the actual number of people that live in those counties, but not always. Interestingly enough, if you go across the number of cases that were appealed, it's 946, striking. The conclusion of this is and if you've heard me talk about this before, I think it's important, just based on these numbers, to understand that a lot of what happens in a forcible detainer case, a lot of what happens in eviction cases happens at the JP level. It's one of the reasons why it's important to take it seriously. It's important to make sure that the judges are following the law.
Developments in Landlord Tenant law, and those include, for example, assuring people who are poor the ability to appeal. For example, appealing from county court an eviction case requires, in order to stay judgment, the filing of a supersedious bond. But there are recent cases that confirm that if you cannot afford a supersedious bond, while you may not be able to maintain possession of the unit in an eviction case, you can still pursue that appeal as long as the case is not moot. And there are a number of other things. There are recent laws that prohibit tax credit properties, for example, from locking tenants out or threatening to lock them out, and from asserting landlord liens against tenants. Things of that sort. There's also something that is a fairly recent law, is the new Texas Rule of Civil Procedure 737 that provides for a process by which tenants can go to Justice of the Peace Court to get an order to repair property. So there are a lot of interesting things that are happening, and some important updates for indigent tenants. Well, some of the most interesting cases that I work on often involve the Fair Housing Act, both at a state and federal level, where tenants often are being discriminated against by landlords. And the Fair Housing Act requires a person, it allows for a person with disabilities to ask for an accommodation, a reasonable accommodation of those disabilities, which is essentially a request to change policies to allow them to enjoy the unit, the apartment, in the same way that anyone else would. And if they ask for that request, if they ask for that accommodation and it is reasonable, then the landlord actually has an affirmative obligation to grant that accommodation. And I've worked on some cases recently that involve people who are elderly, have disabilities, and have faced discrimination in the form of a denial of reasonable accommodations. And I've been, it's very rewarding to be able to keep people in homes and make sure that they're not homeless and can enjoy their unit as everyone else. Well, I think definitely, I think every attorney knows that if you get involved in a case, you can make a difference. And access to justice is such an important part of our legal system. And when you do pro bono work, you're working on behalf of people usually who have no other options and whose cases may very well fail if you're not involved. And second of all, frequently the cases that we do are cases of impact. They're cases where, for example, in the housing law area, if the person, the tenant or the homeowner loses, they will be homeless, and the risk is great. And so I think as a result, the reward is great. When you get involved in these cases, you can have an impact. You can keep people from being homeless and change their lives. And that there can be nothing more rewarding.